And Rob, the big news story yesterday, still today, Jarryd Hayne has enjoyed his first night of freedom since walking free from prison. He was released from Cooma Correctional Centre yesterday afternoon after being granted bail earlier in the day in the wake of having his sexual assault conviction quashed by the Court of Appeal. There are many legal questions we want to ask about this case. To find out more from Conditsis Lawyers in Gosford, which you'll find opposite the courthouse, he is Senior Trial Advocate, Accredited Specialist Criminal Law. It's Manny Conditsis, joins us this morning. Manny, good morning,
G'day,
mate.
Manny.
Good morning, Paddy and Rob.
Mate, thank you for taking time out this morning.
Happy to do it.
Thank you, buddy.
How much, Manny, does chasing justice in this case cost? And does cost become an issue for a government that's trying to get a third trial?
It's not an issue for the government, and even though one would think, I don't have any personal knowledge, that Jarryd certainly was reasonably well off, we would be talking, bearing in mind he's already had 2 trials and an appeal, it'd be well over $1 million, I would say, comfortably.
Quashing a conviction like this, Manny, what was the reasons for in this case?
Put simply, the trial judge has the responsibility of giving the jury directions of law as to how they should apply the law of sexual assault, consent, the extent to which a consent by a complainant could be implied or expressly given, and a whole lot of other circumstances in which the judge has to give practical directions to the jury as to how to apply the law to the facts as the jury find them to be. Simply, the Court of Criminal Appeal held that the judge made not just 1 or 2, but multiple errors of law, regrettably, and because of that, they overturned the conviction.
Does that mean the evidence didn't find him guilty? The judge influenced the jury to find him guilty?
I wouldn't quite put it that way, but certainly the judge's role is to assist the jury in applying the law to the facts. And in her directions to the jury, the Court of Criminal Appeal held that they were wrong. And so in that way, the jury may have been unintentionally misled as to how to apply the law to the facts, and therefore he didn't get a fair trial.
Manny, and speaking about trials, it's anticipated that the trial date will be set down on Friday.
That's so, as I understand it.
And so what will be the procedure from here? Will the trial definitely go ahead?
One can't say, because bearing in mind again, this is the 3rd trial. First trial was a hung jury. Jury couldn't reach a unanimous verdict one way or the other. Second trial, as we know, he was convicted. He was then sentenced, sent to prison. This will now be the 3rd trial. I've been practicing long enough to say that, 20 years ago, the DPP would not run 3 trials. And so one would be pretty confident then that they wouldn't have a 3rd trial. However, in this climate, the Me Too movement and so on and so forth, and the media publicity it has attracted, I wouldn't be so confident to say that there won't be a 3rd trial, but I certainly have some reservations about whether there would be. Also a factor in that is what is the complainant's view. Does she want to go again? So it's by no means confident. Even if the court sets a trial date on Friday, doesn't mean it'll go ahead.
And if nothing goes ahead, everyone shuts the book on this and Jarryd walks away considered innocent of the charges.
Correct. Innocent of the charges, and the unfortunate part about it in that scenario is that he still has the stain of a conviction. Nonetheless, it was overturned. People will ultimately believe what they want to believe.
Have you seen cases like this before, Manny, where they've gone to a 3rd trial and then a conviction has been handed down? I'm not saying with this particular trial, but in other trials, and then the sentence has been given but longer. Can that possibly happen?
It could happen. I'm not aware from my own personal anecdotal experience of it, but it certainly is possible. If there was going to be a 3rd trial, if he was found guilty, then the judge in that trial, when sentencing him, could give him a sentence harsher than what he got by the previous judge. because, guys, it really depends on the findings of fact by that judge in determining the sentence.
Right.
One can't assume it's going to be exactly the same evidence that came out last time will come out this time. So it's possible, but we're a long way from that.
Yeah.
I think a word that a lot of people dislike when it comes to law is technicality. And for me, when you hear technicality in a case, does that mean that there are people walking around who may be guilty, who should be in jail apart from a technicality, and vice versa? People in jail who are innocent and based on a technicality found themselves where they shouldn't be.
I think it's a fair construction, what you've just said, and particularly when you've added the other bit, it cuts both ways. I've got no doubt that there are people who are in custody who shouldn't be. Equally, I have no doubt there are people that are walking free who probably should be convicted. The criminal justice system is far from perfect, but let me say this, in my experience, it mostly gets it right.
Right. Manny Conditsis, I know you're extremely busy. Criminal lawyer on the Central Coast from Conditsis Lawyers in Gosford, opposite the courthouse.
Send your invoice for this chat to Paddy Jarryd at Triple M.
I'll put it to the attention of Paddy.
Thank you.
Payable within 24 hours.
Okay.
Payable within 24 hours, Manny.
Mate.
Mate, thank you so much for taking time out this morning.
I appeal.
Cheers, guys.